The order under challenge is annexure P5 at page number 25, wherein, my lords, the parties are under litigating under the section 372 of the Indian Succession Act, and the application for conducting the DNA test has been turned down, my lord. Page number 27, my lords. The application has been rejected, my lord, on the ground that it cannot be done in a regular course, and as per section 112 of the Indian Evidence Act, the owners and the parties have to prove on their own evidence, my lord. The respondent, my lord, has filed this case alleging that is respondent number 1, Gaurav, had filed this case alleging that the petitioners herein and the respondent number 1 are their fathers, Dr. K.S. Sagar. Was the respondent number 1 was from the first wife, my lord, and from the second wife the petitioners have born, my lords.
Succession का matter है ना ये?
My lord.
You are claiming that petitioner respondent number 1 is from the first wife.
My lord. He filed an application under section 372 of the Indian Succession Act that Dr. K.S. Sagar is his father from the first wife, and from the second wife the petitioners were born, my lord.
जी.
And my lord.
Then?
My lord, then the petitioners herein moved an application for conduction of the DNA test.
DNA test of whom?
My lord, the DNA test of petitioner number 2 and respondent number 1, my lord. The father has already expired.
And then?
My lord, that application
what can be extracted from this DNA test?
My lord, because the respondent number 1 is claiming that if he is proved that Dr. K.S. Sagar is his father, all the pensionary benefits, gratuity and everything may be amounting to rupees 60 lakhs may be granted to him, my lord.
ठीक है. फादर का जो फैक्ट है उसके लिए डीएनए टेस्ट की क्या जरूरत है? तो रिकॉर्ड देखने से मालूम पड़ जाएगा उनके पिताजी ने नॉमिनेशन किया था नहीं किया था केएस सागर साहब ने मरने के पहले. कुछ है नहीं इसमें.
I fairly concede.
Shri Saket Malik, learned counsel for the petitioner, but you have that art for 2 minutes you could almost convince that I thought that chaliye.
It means a lot when it's coming from.
For the petitioner, this petition is filed being aggrieved of order dated 8/8/2023, passed by learned First Civil Judge Senior Division Chhindwara, rejecting an application filed by the petitioners for conduct of DNA test of the respondent number 1 with the sample of respondent number 2 in full stop. Next paragraph. Petitioner's contention is that an application for obtaining succession certificate is pending before the said court. Full stop. Claim of the petitioner number 1 is that she is the wife of late K.S. Sagar. Full stop. Respondent number 1, Gaurav, was born out of the first wedlock of Shri K.S. Sagar. Full stop. Petitioner number 2, Srijan Sagar, is born out of the wedlock between late Dr. K.S. Sagar and Srimati Deepshikha Sagar. Therefore, it was submitted that samples of Srijan Sagar and Gaurav Sagar be matched to determine whether Gaurav is son of K.S. Sagar or not. Next para. After hearing learned counsel for the petitioner, I am of the opinion that the petition is misconceived. Full stop. The fact of the matter is that issue of succession as to who will succeed to the estate of Shri K.S. Sagar depends on the nominations, etc., which were made by Shri K.S. Sagar on record. Full stop. It is not in dispute that respondent number 1, Gaurav, is son of Shri K.S. Sagar. The only dispute is that he was born from the first wedlock whereas the petitioner number 2 is born out of second wedlock with the petitioner number 1. Therefore, once it is not disputed that Gaurav is son of Dr. K.S. Sagar from his first marriage, then there is and when the issue is in regard to successors of Dr. K.S. Sagar, then admittedly Gaurav is one of the successors of Dr. K.S. Sagar because it is the paternity which is not in doubt, and therefore no useful purpose is going to be served by ordering DNA. Full stop. DNA test. Thus, impugned order when tested cannot be faulted with petition fails and is dismissed.
Okay.